Hi, this is E.W. Claville, and this is the Claville Report. The U.S. Supreme Court and the dramatic shift to the right. You know, I've done a segment in the past on this on the Claville Report that talked about Mitch McConnell and the plan of the Conservative Party movement in order to create the court itself to be more conservative or more to the right. You know, it was a plan that started 40 years ago. It was a plan that took not just a large leap when we see the Supreme Court, but it's a plan that took incremental steps on the local, on the state level, and of course, what we call the federal level, with various courts, the district courts, the Court of Appeals, and then now culminating at the U.S. Supreme Court. It's a plan that we saw in full effect this last term. As a matter of fact, according to the New York Times article, it says a transformative term at the most conservative Supreme Court in nearly a century. Look at blockbuster decisions on abortions, guns, religion, climate. That simply told part of the story, but the article says, but the court's abrupt rightward shift ran through its entire docket. It says the Supreme Court moved relentlessly to the right in its first full term with a 6-justice majority. 6-justice majority. I want you to think about that for a moment, and we're going to address that in just a second. But 6 justices, only 9 on the Supreme Court, just 9. And 6 are now conservative. But they issue far-reaching decisions that they believe will transform American life. As we just talked about, eliminating the constitutional right to abortion, recognize the Second Amendment right to carry guns outside the home. They made it harder to address climate change and expanded the role of religion also in public life. Matter of fact, Lee Epstein, a law professor, is quoted here in political sciences at the University of Southern California, who oversees the Supreme Court data. He stated that the data provides stunning confirmation for the Republican conservative takeover of the Supreme Court. As a matter of fact, it also states that according to David Cole, who's the national legal director of the American Civil Liberties Union, he says every year since John Roberts became Chief Justice, the court's results at the end of the term have been less conservative than many court watchers feared they would be at the term's outset. He said, but this time, the doomsayers got it exactly right, as the court traded caution for raw power. Caution for raw power. There's this phenomenal, we look at this graph that shows in this particular article. We want to go back and look at the article. It's a New York Times article that I'm reading from. Entitled A Transformative Term at the Most Conservative Supreme Court in Nearly a Century. It's a July 1st article, 2022, but it's definitely one that's relevant to this day, because one thing I want to talk about is not so much the decisions, but how we got to where we are. Okay? How do we get to where we are? How are Supreme Court justices, how do they make it there? Do they run a campaign? Do they lobby for themselves to be on the Supreme Court? Or is there a concerted effort in order to ensure that the court itself has the justices that the government wants or legislators wants? Well, let's take a look at that first. You have 3 tiers of courts here in our country as it relates to the federal court. And many states adopt what the federal model is. So in many states you have local courts, or what we call district attorneys or Commonwealth attorneys. And then on the mid-level you have what's called appeals courts, or Court of Appeals. And then on the top level you have one Supreme Court in every single state of the union. And then you have, on the federal level, you have the same structure, which again, the states adopted that structure for their courts. So on the lower level, you have what's called district courts. In district courts, you have what's called, they're the equivalent of district attorneys. In the states, they're what's called U.S. attorneys. So you have U.S. attorneys for district courts, which is the trial level court of the federal circuit. Those individuals, you have various districts across the state. So in some states, you have a large population. So you have multiple federal district courts. And of course, throughout these district courts, they govern different regions. So if you break federal law, you go to this federal court. If you break this federal law, you go to this federal court, depending on where you live. Well, that's the trial portion, right? And as the saying goes in the federal circuit, as a U.S. attorney, you can indict a ham sandwich, right? In other words, charges can be brought against you. But the question becomes, like anything, will those charges come to light? Will those charges actually be persecuted in the purview of the public, or will they come to the point where you actually go to trial? Many times it doesn't happen, but when those things do happen, you are part of the federal court system. Now, you have the right to appeal that decision. That's one great thing about our legal system. You have the right to appeal that decision. When you appeal that decision, it goes to what's called an appellate court. And the appellate court is a panel of judges or justices, I would say. So in the district court, you have one judge sits on the bench. On the appeals court, you have multiple justices that sit that will give a decision about that. Now, in some parts of the country where you have multiple district courts, you have a small panel of judges, but you can request a full court of appeals, which now you appeal that decision to the full appellate court. And once you do that, that decision is now rendered. Many times, unless it is a major cultural decision, many times that decision will be the only decision that will be decided, and that becomes the decision of that particular case. In other words, you can appeal it to the U.S. Supreme Court, but it's not guaranteed that they're going to hear it. As a matter of fact, you get less than 150, sometimes 160 cases that are taken up per session or docket for the U.S. Supreme Court, over 8,000 that are appealed. So think about it. If you put in an appeal to the U.S. Supreme Court, and there's 8,000 other cases that come before you and say, hey, I want to be heard as well. Well, you probably got a better chance of winning the lottery or a scratch-off ticket than getting your case heard before the U.S. Supreme Court, unless it is a major issue of society. And of course, according to this article, we've seen major issues such as abortion, such as role of religion in public life, such as gun rights, climate change, and the like. So these things we see make it to the U.S. Supreme Court because, again, they are issues that decide our constitutional issues in our country, and they have far-reaching effects across the board to every person in society. So let's just say you get to the U.S. Supreme Court, you make it there. The decision is given. That decision becomes final. Period. The saying is the Supreme Court, they're right because they're final, but they're not final because they're right. They're right because they're final, but they're not final because they're right. What does that mean? It doesn't mean because the Supreme Court makes the decision or decides a case that is the right decision. But it is the final decision because that's the only place you can go. There's no other place that you can go. That's it. You're done. Now, what can happen? Now, you have the opportunity where the Congress can actually pass a law that overturns that decision. Well, I'm sorry, that overturns the effect of that decision on other persons. But for you, that decision is final. Case in point, the Ledbetter law. Ledbetter was a female in Mississippi that basically she was constantly passed over, working in a factory setting where her male counterparts were getting raises, and she was constantly getting passed over for promotions, raises, and so forth. And she filed the case. She filed a suit, and it went all the way up to the U.S. Supreme Court. And guess what? The court decided, especially on the clear summary, they said, "Hey, you're right. Yes, you were discriminated against. Absolutely. You were a woman doing the same job. You should have been promoted over these men. In many instances, you should have gotten the same raises. Yes, you're right. But they decided their case not on the facts of the case. They decided on the technicality. They said, well, yeah, you're right, but you should have filed it at the first instance of discrimination 20 years ago, as opposed to now, the last instance of discrimination. So the case basically was ruled against her because they decided that the case should be filed 20 years ago, as opposed to now. Well, the very first law that President Barack Obama signed into law was the Ledbetter Act, which they basically stated that the statute of limitation runs with every single case now, every single case, every single instance of action that causes discrimination or or an injustice, a harm. So case in point, even though she was discriminated against for being passed over 20 years ago, if she's discriminated against and being passed over again 20 years later, then she could bring that case can be brought. But for her, that's her final decision. But for everybody else, because of her and because of the backstop against cases and decisions of the Supreme Court, others are able to now have that action. But how do we get to this point? So that's a quick overview of where we are. But how do we get to this point where the court has shifted from the left to the right? Supreme Court justices and district attorneys are recommended to the Congress for approval, recommended to the Congress by the president for approval by the Senate to serve in those positions. So there's a recommendation that's given by the president. It goes to the Senate. They have to approve it. Now, back in the day, which a provision that stood for since the beginning of this country, said, hey, yeah, you got to have a 2/3 majority. Why is that? The framers felt that even though we have different parties and different factions, if you can get 2/3 majority to agree on one person, then obviously that person has to be a certain type of moderate and not an extreme of views and ideology. They were right. Many of our courts, we have moderates and persons that became moderates that serve on there. So you got a lot of balanced decisions. However, Mitch McConnell said, hey, you know what? We're going to implement the nuclear option, which simply means that you only need one vote more than 50%, 50 plus one. And in that way, just who I call Justice McConnell was able to stack the court during the time of Donald Trump's presidency. So what happened during that time period? According to this article, it says that can be only the consequence of three justices President Donald Trump named to the court, particularly appointment of Justice Amy Coney Barrett, who joined the court after the death of Ruth Bader Ginsburg in 2020. So you take a look at the court itself. This chart shows justices and their ideology based on voting patterns. Justice Sotomayor is considered the more liberal of the liberal justices. In contrast, Justices Alito and Thomas are considered the most conservative of their party. In the middle, for the most part, of each party is Justice Kagan and Breyer, who are considered more moderate. So Justice Kagan and Breyer are considered moderate liberals. But Justice Roberts, Gorsuch, Kavanaugh, and Barrett are considered also moderate, conservative. So you have now this tug of war. You have 2-1 conservatives, all right, that are more conservative than the liberals, and you have 4-2 conservatives that are considered more moderate than the two liberals. No matter which way you shake it. Now, keep in mind, under Donald Trump, you have three justices, that are considered, that were appointed under him: Gorsuch, Kavanaugh, and Barrett. By far, this was the biggest feat for conservatives, the biggest win during the Trump administration. By far. Why is that? These justices will now become by the way, Justice Breyer was also replaced by the first black female Justice Ketanji Brown Jackson. So I want to make sure that we understand and know that I was able to be in the room during the confirmation time period. But again, this is the time period of this particular chart from left to right. However, I would place her in Justice Breyer's position, still a moderate, because she clerked for him in the whole nine. She's a moderate. She's a moderate liberal. But this is the first Black female on the court is now here. As a matter of fact, there are no male liberals. No male liberals on the court. You have three women, one African American, one white Jewish American, and one Hispanic American that are on the court that are considered liberal justices. We've never seen this before in our country, and this is a feat within itself. And then on the right side, you have 4 white males, 1 Black male, and 1 white female. That's our court. And why is this such a feat for this particular conservative group? Because these decisions are going to decide our laws to have reverberating effects for the next 40 years. Think about that. The decision we see now decided your children and your grandchildren will be affected by it. Elections have consequences, and political strategy always wins the day. So we'll be viewing this Supreme Court and how they actually rule on various cases moving forward on many decisions. So stay tuned to the Claville Report as we take a look at the Supreme Court, its impact of the justices, and its decisions. We'll see you next time.